Hey everybody, welcome, 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 welcome. I'm working on a banner that I could put on the bottom of the channel. Just give me 1 second. Not contact any persons or subjects discussed on this channel on this stream. Okay, sorry y'all. 1 second. This is important. I think it's important. Yes. All right. Let's see if my goodness, it's really big. Was hoping to make it smaller, but shout out to everybody in the chat. Thank you guys for being here. Welcome, welcome, welcome. For the record, hey that girl, how you doing, love? Hey everybody, welcome. Please don't contact any person or subject or subjects discussed on this channel on this live stream overall. Just don't talk to, don't contact them, don't message them, don't email them, don't at them, don't nothing. Okay, I thought that was important to put out there given that people like to make accusations about that. So I figured I would put that out there. Welcome everybody. Thank you guys for being here. Why is this table shaking? Welcome, welcome, welcome. Hey there. I'm gonna let people to some time to get in here. Oh, well, thank you. Thank you. Yeah, don't touch that shit. Don't break nothing. Don't do anything. Uh don't do nothing. Okay? Be nice to everybody. I'm always here for some good Lima tea. We're gonna be talking about some stuff. Welcome. Hey Monica. Ronnie, I see everybody cheeks. Wim's like, I'll see if I'm awake. Shout out to Wim. Hopefully he's getting some rest. Welcome everybody. Oh my goodness, we about to get into it. You finally caught another live. Oh my god, that's awesome. Hey B. Hey 1984 by George Orwell. Welcome. Thank you for being here. Emily, everybody, Pika. Yes, yes, yes. Nicole, Jane, Ada, Fabulous Fab, SW. I'm here but barely. Welcome to you. So, Ronnie G, welcome, guys. So, we got to talk a little bit about what is going on with the Lima Jevremovic versus BJ lawsuit. Okay. You guys know we've done content here and there as it pertains to, especially to get the information out in the news with this whole lawsuit with BJ. Um, Interesting information came through, and I'm so glad that it's a bit of an update as far as what is going on and what they're planning to do. We do got the docs here as well, so we'll look into those. And it's actually not a very lengthy read. It's just a very less than 20 some pages, even though it's numbered. But it's not too bad. Welcome everybody. I'm just giving people some time to get in here. Welcome, welcome, Jojo. Welcome. Thank you for being here. Listen. Welcome, my love. Welcome, welcome, Glow. Thank you. I hope you guys are doing well. It is like Saturday. No, feels like a Saturday. It's Friday. No, Thursday. Shit, my days are off, you guys. My days are so off. You don't even know. Welcome. Thank you guys. All right, let's get started. I'll probably put it like a timestamp for those that are just wanting to get to where we need to go. Okay, so let's get into it. Um, we have the information wise that Lima filed the original defamation lawsuit back in August of 2022. BJ and her attorneys filed a motion to dismiss in October of 2022. Almost a year went by and the court dismissed it without prejudice. Dismissed it without prejudice, giving Lima the opportunity to cure her filing. There were two issues with their filing. She didn't show that BJ's comments weren't protected speech, and she didn't show that she made statements with actual malice. So kind of keep that in mind. The court said that she could try to fix it, which she did try. She was pretty much Lima was pretty much upset, at least from what we can tell, that she lost and went to try and get a restraining order in California. We saw all that go down as well, which has now been dismissed under the anti-SLAPP, and she owes BJ's lawyers, I don't know, a good 87,000 K over. Okay, she owes that money, y'all. She owes some money. It's a lot of money to owe. She refiled another restraining order, and it said that she refiled this illegally and improperly in California. The attorney, BJ's attorney, did file some sanctions, okay, against her and her lawyer for these inappropriate filings. I'm wondering too, and I hope that these sanctions do go through. I mean, Lima will withdraw the filing, I'm pretty sure, inappropriate filing, that is. But I'm pretty sure that the lawyers already got the sanctions and stuff. Like, you can't be doing this, girl. Stop it. So it'll be a little too late for her to get through all these filings and whatnot. Um, what do y'all think? Because like cha-ching, cha-ching. Listen, I mean, I don't know. BJ deserves all the monies, all the shmoneys because I'm serious. Like, this has been a lot. Watching and giving commentary on the side about what's been going on and the level of like harassment that she's received. Lord have mercy. I mean, I see it. It's pretty bad. And so yeah, let that girl do what she's got to do. Let that girl do what she's got to do. She had to know the mess she filed wouldn't go far. Well, you would think that somebody would have like, you know, say something to her. Like, they filed it like improperly and illegally. I mean, are you sure you hired some attorneys? Because damn, like, I don't know. Something's up with that. You said Lima's lawyers must be scared to say no to her or they're getting greedy. Something. Hey, I've got words. Hope you're doing well. It's been a minute. Jojo, it's got to be something because like to risk to get risking getting sanctioned, like do they know or do they just not care? I don't know. I'm just like yeah, as far as that BJ and her case and everything that has happened, it's always kind of like made me side eye everything, you know? Um, and this is why I say, like, listen, everybody should be, anybody can get sued at this point and improperly, illegally, and everything. And so it's kind of scary how all this kind of goes down. I mean, I don't feel like there's a lot of protection for anybody. So BJ's attorneys put in a defendant's reply memorandum of law in further support of its motion to dismiss. All right, so we're going to get into some of this stuff. Now, what I really like about the filing is just look at all these table of contents. Look at all this, like page one, and it's only 21 pages. And it's not even 21 pages. I mean, if you take away these pages, it's really just about, I don't know, like 15 pages, if that. Very nice. Well done. I'm still getting PTSD from 300, almost 400 page uh whole filing that Lima and her attorneys did. That was a lot of paper. And just going through that was just like crazy. Crazy. Lima's not the best with boundaries or the truth. Well, damn. This is interesting. And I mean, I'm glad that hopefully everything will go through and everything's fine. And so this is where we're at. Essentially, this should be the last filing um, in the case before the New Jersey federal court. Hopefully, and hopefully they make a decision about where to go next. Hopefully. I've got where it says, I know. I mean, we're all cheering for BJ. It's been a trip. Like, it's been a trip, I'm telling you. And as an outsider seeing everything that went down, it's been a bit of a trip. Sure has. So let's read into this a little bit. This is the argument. Here we go. Plaintiffs have not adequately pled defamation claims. Plaintiffs are bound by the law of the case and may not relitigate issues already decided by this court. And I'm going to stop here and there just to read some comments and let me, just to highlight some of the things that you guys are saying. Very important. But we're going to run through this. Hopefully, it'll be a quick one. It won't take too long. Anyone can sue anyone in the US and run up that tab. Legal financial abuse happens every day. Right, Emily? You ain't never lie. It's crazy. Um, yeah, it's very true. very frivolously. We've seen that time and time again here on YouTube. You have frivolous people. Definitely. You said Lima's attorney claimed that she couldn't afford to pay her own lawyers, let alone the 87K order. BJ's attorneys responded that she's free to drop the frivolous lawsuit. Yeah, why don't you drop it? You can't pay. I mean, I don't understand that. Can't pay it, drop it. Well, where did this money come from? I don't know. Positive vibes for BJ. Maybe that's why Soft White Underbelly is putting that you know what? That Whitaker, excuse me, signed book on eBay to help Lima. Lord have mercy. Allegedly. And please don't contact any of these people, okay? When her anger due to her exposure has her seeing red. Color me Oakland, you ain't never lie. And isn't that funny? It's so funny because I still have some of the Mark Leda supporters in my chat because they're mad that I had called and I had said what I said. And I said, listen, I said what I said. That's what I said. Mhm. Get a hobby. That's what I said. That's right. Thank you, love, for putting that up. Okay, let's get it together so I can get through this. Shout out to everybody. People are so you ain't never lie. All right, let me stop. And by the way, I love talking to you guys on the chat. This is pretty chill, so this is how we gonna do it. Okay. Plaintiff's opposition appears to ignore the fact that in dismissing plaintiff's original complaint, this court already made certain filings that the challenged statements set forth in the original complaint are non-actionable because they are protected opinion because there were no particularized allegations of actual malice. These findings are law of the case. To the extent plaintiffs are attempting to relitigate these issues already decided, they are barred from doing so pursuant to the law of the case doctrine. This includes plaintiffs' attempts to re argue the social media context of Corville BJ's statements, as well as the implications of Corville's legal background. Factors this court already considered in arriving at the conclusions set forth in the opinion. While the court allowed plaintiff to plead additional factual allegations in response to the opinion and actual malice findings, plaintiff may not rely on the same factual allegations and ask for a different result. Huh, that's interesting. Let me see what I can read. And by the way, there's a lot of footnotes here, so I'm going to see what I can pull that I find interesting. Number two, indeed, plaintiffs cite repeatedly to the opinion and rehashing these same arguments and the point to the court to that the court prior opinion did not view a particular challenged statement that appeared in the original complaint in its full context in reaching its prior determination, and that the court's prior analysis omitted the important signal. Mm-mm-mm. Yes, 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 yes. Hey, Poe, welcome, welcome. How you doing, Poe? Hope you're doing well. Yes, Terry. It is so sad that someone who's trying to stand up for people who have bodily autonomy is having to fight against people like Lima. You ain't never lie. You ain't never lie. But it's an example of how far people will go to try to twist your words, to try to silence you and everything. You still love BJ's impression of Lima. Her impression takes me out. She is reaching for Jesus and it's not working. She's reaching for Jesus, you know? Right. In 2024, I hope people are better able to separate being rude versus constructive criticism. Color me Oakland, you know that that's not going to happen on the internet. That's a hard one. You know, that would require all of us to have a level of emotional intelligence that would be just superior to a bunch of things. It just can't happen. Can't. But I think that's a great comment, though. We will Holy Spirit activate afterwards. Y'all are too much. Oh my God. All right. All right. All right. All right. Get it together, people. Get it together. Okay. Where did I leave off? See what happens when I get distracted? So, okay, that is Here we go. Hold up, hold up. If plaintiff had any disagreement with the court's prior opinion, they were required to either seek can't read, reconsideration or interculpatory. Is that how you say it? Interlock? Hold up. Let me pull this word. Y'all know I'm not a legal attorney here. Interlocutory, which means given provisional during the course of a legal action. Okay, that's how you say that. So, required to either seek reconsideration, appeal. Plaintiffs chose to do neither. The opposition does not address the limitations of the law of the case doctrine. To the contrary, plaintiff seemingly concedes that they are bound by this court's prior opinion. Wow. Okay. And then B, plaintiff did not allege any additional factual allegations to move the needle on the court's opinion and actual malice findings. As defendants set forward at length in their opening brief, plaintiffs do not point to any additional allegations that would negate the court's findings on opinion and actual malice. As to opinion, plaintiffs merely add allegations about Corville's legal training. Despite the courts rejecting the relevance of these types of statements when viewed as a whole against the entire context of Corville's statements. Plaintiff failed to add any other allegations that changed the court's analysis of the context of Corville's statements as indicia of opinion. Indicia of opinion. You know that is Latin. As signs, as distinguishing marks of opinion. So everybody's aware. Yes, yes, yes. Thank you, thank you. Yes, hit that like button. Thank you, thank you. Oh, Lord have mercy. Y'all, let me stop a little bit. Look at the chat. She's reaching for someone because she ain't got it all and knows damn well that she's, oh no. Chico. Ada, welcome. Welcome, welcome, welcome. When all this is done, I hope BJ goes after her for all the lawsuits in. Yes, I would hope so too. I hope so too. I cannot. Simply Monica said it was in the first filing. Look at Simply Monica. Look at Simply Monica. She's saying over here, shout out to her. She says, Lima actually added a complaint regarding BJ's impressions because it hurts her feelings. It was in the first filing. I think I remember that actually. But what? Okay, so what if I was a comedian, which I'm not? Okay, I'm not like a blogger and then comedian. Shout out to Tasha K. She went from being like a big blogger to now a comedian. I cannot. But like, what if she was and she decided to like, make impressions of you? I mean, you got to do what you got to do to keep people, entertained. That's what you do. You said she hurt her feelings. Lord, what a fragile, fragile soul. I mean, I don't know. It did hurt her feelings. Listen, it hurt her fifis, her feelers, her fifis. I'm just saying. It's the fifis. All right. Yo, all right, stop because I'm thinking of BJ doing like the voice and it's like playing in my head and it's very distracting. So y'all need to stop. Okay? And wait, Erica, now are impressions, are they still protected free speech? I'm just saying. Mm. Let me know. Hold on, I gotta chew on this ice. This is not an ASMR channel. I'm not trying to chew on your ear. Okay? Let's keep going. Y'all are too much. Y'all are too much. Her feelings, fine, but you can't sue for hurt feelings. Are you sure? I want to sue for hurt feelings. Are you sure about that? Okay. Let's keep it going because I lost my spot. So, all right. And as to actual malice, plaintiffs failed to engage the court's directive that only sufficient particularized facts showing that Corville, in fact, entertained serious doubts as to the truth of her statement would satisfy the actual malice standards. So they cite the opinions there. Plaintiff's opposition instead throws out different, unsupported, and minimal standards for actual malice in the attempt to create a low bar enough for their threadbare allegations to meet. For example, plaintiff suggests that the accusations of criminality are entitled to the presumption of malice per se. This is not the law, nor as set forth in details below. Did plaintiff plausibly plead any suggestions of criminality by Corville? Again, these arguments are simply an attempt to avoid the actual malice standard as this court in this case had already uh, articulated a standard that is admittedly a high bar that is purposeful. You cannot, listen, you cannot, you cannot, like, this is interesting. So they didn't meet the standard of actual malice. So this is like you just throwing shit out there and see what sticks, pretty much. Right, Terry, you ain't never lied. Look at the what the hells. Like even what they're going through, very similar to what BJ's going through. I wonder if BJ's aware of that. She needs to watch some of those streams. It would, I'm telling you, that would drive her like insane. The insanity. Hey Vic, the insanity. They would drive her crazy. But this is the shit that people go through. Like, she needs to watch some of those. One of her rabbit ears got bent. Ooh, that sounds painful. That sounds so painful, you know? As long as it doesn't rise to being defamatory. Right, right. Yeah, listen, BJ has been in India. If y'all watch some of her stuff, I mean, it's just beautiful. I wish. It's just gorgeous. I mean, she's looking like she's having a great time. Her and her, fiance. Shout out to them. I'm so happy that they're, enjoying themselves. That case will blow up BJ. Yeah, she will definitely hate it and she'll hate the judge. Like that's what she needs to look at. I mean, I know she's busy, but I wish get it in her ear, y'all. I mean, everybody over here was messaging me nonstop about it, and we've been talking about it, right? Get it in her ear, and I'm sure she'll look at it. You know what I'm saying? I know the pics look awesome and they're beautiful, right? She looks gorgeous and happy. Good for her. Good for her. All right. She's living her best life. She sure is. Okay. Let's get it together. Plaintiff's only attempt to specifically argue actual malice is the hypothetical suggestion that had Corville done further investigation, such as having conversations with Amanda Rabb's doctors, Corville would have learned that Miss Rabb was at a treatment center not controlled by plaintiff and that plaintiffs were not responsible for Miss Rabb's death. The allegations about doing further investigation appears nowhere in the TAC. It is an argument made for the first time in opposition to a motion to dismiss. Actual malice must be alleged in the pleadings, and attempts to amend the pleadings through an opposition to a motion to dismiss are improper. Excuse me, yes, are improper. Sure I read that correctly. And then they give some sightings. Hold up. Again, it is axiomatic that the complaint may not be amended by the briefs in opposition to a motion to dismiss. So that's some citations there. In any event, Corville never stated plaintiffs were responsible for Miss Rabb's death. So the straw man argument plaintiffs set up is irrelevant. Even setting that this positive fact aside, plaintiffs themselves conceded that failure to investigate alone may be insufficient to show malice. While plaintiffs argue that internal inconsistencies or apparently reliable information that contradicts its libelous assertion may qualify for actual malice. No such inconsistencies are pled in the TAC. Plaintiffs referred, yeah, excuse me, plaintiffs reference, excuse me, two podcast appearances, which they argue contradict Corville's narrative that Jevremovic lied about Miss Rabb's cause of death. But as pled in the TAC, these appearances only confirm that Jevremovic had provided inaccurate information about Miss Rabb's cause of death. She stated Miss Rabb died of natural causes, where, in fact, in her formal autopsy report states that she died from cardiac arrhythmia with hypertension, obesity, and schizophrenia as contributing factors. Yeah, okay. Let me stop right here. She misinformed. Lima Jevremovic misinformed the public about how Amanda Rabb died. Okay? She led the public to believe one thing and then it was another. Nobody's that's what happened. We all saw it here. And I am not the only creator, but there's a gazillion other creators that pointed that out. She did, thank you, Sunshine Rainbow. She didn't think anybody was going to question her. She didn't think, she thought she could just go to one podcast that has, I don't know how many subscribers, to say one thing and then go to another podcast and say a different things. She did you did the misinformation. And what people did here is they try to put the ish together to figure it out. Anybody could have told her this. Anybody. We saw this shit played out. So who lied? Who's defaming who? Jojo, she could have said nothing about the matter. She could have said nothing. She could have not talked about it. Right? Like she could have not said nothing. She didn't have to go to the podcast. She didn't have to talk about it, but she did. Why? Because the case was of public interest, right? So Amanda Rabb passes away. Can't dispute that. You know, a lot of it is so sketch. Myself and other creators have made commentary about this, right? You went up there as somebody who was knowledgeable about the things that Amanda Rabb was going through, and you said it that this is what she passed away from, and then you went somewhere else, and then the documentation says something different. This is the age of the internet. Everybody fucking FOIAs everything. Nobody's safe. So which one is it? You walked into this. They could have just not said anything. They could have just let Amanda Rabb, unfortunate situation. She could have written a public statement on her website. It's a lot. It's a lot to kind of, I mean, Sunshine, right? And that's the other factor too. Is the sisters. Lima wanted an investigation of her death, and or thought one should be done. So why hasn't she? That's a great question. I mean, what other follow up has she done to this? I think that's a great question. So somebody pointing out the inconsistencies, somebody pointing out the things that don't make sense to us, the non-lawyers, the regular schmegular folks like all of us here. Yeah, we noticed it. Like we all saw it. She did. Thank you. She got busted. She put that in her. She did it. Two peas in the pods, free, right, right. Free speech is dangerous to them. Anybody having an opinion, I'm telling you, like, you can't have an opinion, okay? You have to view these individuals as Mother Teresa, okay? And even people had opinions about Mother Teresa, okay? They're like assholes. Everybody got one. Everybody got an opinion. All right, let's keep reading because it's got to get ahead. Okay, so we read that part. Um, let's see. Acknowledging that the discrepancies between Jevremovic's descriptions of Rabb's cause of death and the official autopsy report. That Jevremovic used her podcast appearances to blame the Clark County coroner for this false information is irrelevant. It does not change the fact that Jevremovic did provide false information about Miss Rabb's cause of death. Girl, you did. Own it. You provided false information. Nobody's lying about that. You did. You did. More importantly, it undermines any suggestions that Corville made the statement knowing it was false. Mm-mm-mm. Finally, plaintiff only attempts to make an actual malice argument. Deficiencies, excuse me, deficient as it is, as to these specific statements about Miss Rab's death, but actual malice must be pled for each alleged defamatory statement and for each defendant. Plaintiff's failure to do so here necessitates dismissal. Here we go. So, oh my God, and this is so interesting. The attorney quotes the a case from the Church of Scientology versus Time Warner Inc. They're like, let me bring up the Church of Scientology many lawsuits that they have. Yes, yes, yes. Plaintiff's new argument about statements suggesting criminality finds no support in the case law or in the TAC. Unable to overcome the pleading deficiencies that led to this court's dismissal of their complaint, plaintiffs resort to a new argument. They argue that accusations of criminality are per se defamatory, and they then try to stretch Corville's statements to an unrecognizable degree to argue that they are somehow accusations of criminality. Plaintiffs are wrong on both accounts. Let me drink some more water. My throat is drying up. hmm Jane's like, what? Yes, Jane. Yes, yes, yes. They do. They do. Um, let's see. Let's see. Let's keep going. First plaintiff blatantly misstates the law. Accusations of criminality are not per se actionable as defamation. Rather, these statements are subject to the same analysis as every other defamatory statement. Okay. Plaintiff selectively quotes from and they cite the source for their misguided legal theory. But in that case, the New Jersey Supreme Court did not find that an accusation of commission of a crime falls outside of any protection as an opinion. The holding was quite different. Any statement that may refer to criminal conduct must be examined in context in order to determine whether the reader would be left with the impression that the plaintiff was being accused of a crime. Language that could reasonably be understood as implying specific criminal acts on the basis of undisclosed factual allegations does not fall within the opinion protection. Mm. In other words, an opinion statement suggesting criminality can still be protected opinion. These statements are actionable as defamation only if they are based on false facts, or if the facts on which they are based are not disclosed. That is not a special rule for allegations of criminal conduct. Second, plaintiff contrive attempt to twist the challenged statements into suggestions of criminality defy logic as set forth in the details below. Number one, none of the challenge statements are plausible read as accusations of criminal manslaughter. And yet another blatant disregard for the law of the case, plaintiffs tried to litigate whether Corville's statements concerning Amanda Rabb's cause of death constitute defamation. Specifically, plaintiff challenged Corville's statement that Jevremovic did take over Amanda's life in healthcare in order to give her an experimental treatment. And Amanda Rabb, as you know, did not survive the treatment. She passed away in the treatment center in the Aura she passed away in the treatment center in the Aura treatment center. And then Lima lied about how Amanda died. These allegations are substantially identical to those this court already found non actionable. Moreover, as set forth in the defendant's opening brief, these statements are not defamatory. This paragraph simply recites the undisputed fact that Ms. Rabb died while under Jevremovic's care in a court ordered treatment program and while receiving treatment provided by or funded by Jevremovic and Ara. That's it right there. That's an opinion? I mean, it is what it is. Ooh, you said BJ slap claim is a masterclass in the current social media defamation landscape. There you go. Mm-mm-mm. Right there. Let me see what I can read on the comments. Hold up, y'all. You said Lima lied. Well, I mean, There was a lot of misrepresentation, that she said one thing, she didn't say the other thing, but she put it out there. Nobody put it out there. She did. Yeah, she said, but what had really happened was, this is what had really happened. No, she let the public know that she was working and, this is how her shit was getting paid and the donations and yada, yada, yada. This is what she was doing. She was like, what had happened was, guys, this is what had happened, you know? Mm-mm-mm. Okay, let's keep reading. Plaintiffs do not allege that any of these underlying allegations are false, nor could they, as each find supports in plaintiffs' own pleading. Okay, let's keep reading. Um, um, um. Plaintiff's argument that they pled that Lima is not a criminal. Plaintiff's argument that they pled that Lima is not a criminal is irrelevant. The inquiry is whether plaintiff have pled the falsity of underlying facts. Accompany these statements, and here plaintiff have failed to do so. Mm. Plaintiffs try a new track in their opposition, twisting Corville's words to the point of non-recognition by arguing that the statement in paragraph 133 of the TAC can be reasonably read to imply Lima committed criminal manslaughter. Yeah, that was interesting. But this is pure invention. Corville never accused Jevremovic of criminal manslaughter. Out of all the lies and out of everything, okay? All the time that I have seen, all the lives that I've seen, I've never seen BJ say, you are guilty of criminal manslaughter. You are guilty of yada yada yada. No, 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 no. No, 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 no. No. She's just pointed out the inconsistencies in some of the things that's been reported. That's what she did. That's what she did. She didn't like it. Okay. Well, I mean, that doesn't mean that she never accused her of that. I saw those lives. I mean, I saw them. Indeed, no reasonable person could have read the statement in 133 and understood them to suggest criminal manslaughter. Yeah, I didn't understand that. To illustrate the absurdity of this argument, a statement that a patient did not survive chemotherapy treatment for cancer does not necessarily equate to a suggestion that the doctor is being accused of criminal manslaughter. Right. If, and that's a good point. If somebody has cancer and they didn't survive chemotherapy, would they be accusing the doctor of manslaughter? It doesn't work that way. It's a good point. Shout out to the attorneys. This is like phenomenal. Um, the imputation of criminality here is equally unsupported. Even if the court were to credit this blatant mischaracterization of Corville's words, that does not end the inquiry. As discussed, and contrary to plaintiff's mischaracterization, uh, imputations of criminality are actionable only if they are based on false or undisclosed fact. And here, neither of those conditions are met. Here, the underlying facts are all disclosed. That Jevremovic obtained a court-ordered treatment for Miss Rab, and that Miss Rab received Aura's treatment, and that Miss Rab did not survive. That's it. Nor are these underlying facts alleged to be false. Number two, the challenge statements are not an attribution of pornography. Oh Lord, this is the interesting part. Hold up. The challenge statements are not an attribution of pornography. Plaintiff's next example of purported criminal imputation involves the following Instagram post by Corville, a screenshot of the Facebook profile of Lima Mora with the caption, "Who's she?" Okay. As an initial matter, plaintiff did not list this statement as one of the enumerated defamatory statements in their TAC. The complaint must set forth the defamatory statements challenged. Okay. And plaintiff may not, through their opposition, do a motion to dismiss, attempt to amend their complaint again to do so. In any event, the argument that is posted, in any event, the argument that this post on its own suggests that Lima was moonlighting as a pornographic star Lima Mora is layering implausibility upon implausibility, as set forth in the defendant's opening brief. The photo is a Facebook profile picture without a single commentary by Corville about Ms. Jeromovich, let alone any statement at all about Lima Mora, moonlighting, or pornography. I remember seeing that picture, and I mean, she's posing. That doesn't mean that she asked her who is it? Who's she? Who are you? You know? Mm. Okay, hold up, hold up. What are you guys saying in the comments? What are you guys saying in the? Oh, this is definitely a Holy Spirit activate moment for sure, for sure. We will definitely get there. A man died in her care, and if a child dies under suspicious circumstances, the caregiver is responsible. Conservatorship is like a parent-child. Oof, Lord have mercy. Lord have mercy. I mean, but it just left a lot of questions. Just just the facts, and the facts ain't defamation. That's right. I need to find my facts ain't defamation shirt. That's it. That's all. Okay. Who is you, Bish? That's what she said. Who is you, Bish? You piece of- She's like, who is this? Who is you? Who are you? Lima took it a little too personal. Well, um, I just don't know if online promotion of aura or, what is it? That kind of treatment is a good way to for her to do that. She doesn't seem like she's made for online. Like, especially if you're suing for things like that. Just saying. Okay, let's keep going. In any event, the argument that is posted on its own is who is the moonlighting. Okay, I read that part. As set forth in defendant's opening brief, the photo is a Facebook profile picture without a single commentary by Corbell about Ms. Jeremovich, let alone any statement at all about Lima Mora, moonlighting, or pornography. In a simple question, in simple simply posing a question, Corville did not assert anything at all, and certainly did not assert a verifiable false defamatory statement of a fact, as required to plead in defamation. Indeed, plaintiffs concedes that the screenshot in the TAC was not of an OnlyFans page, but rather of a Facebook profile picture. Okay, so the supposed implications that Jeromovich had an OnlyFans page is entirely of plaintiff's own creation, and plaintiffs only supports for the proposition that the post implicated Jeromovich in pornography is a comment by someone else, not Corville herself. That states definitely her. Somebody commented in that picture, definitely her. This statement, standing alone, is meaningless. It is not clear to whom the her is referring, nor does it in any plausible way connect the post to Jeromovich, to Lima Mora, or to an OnlyFans, and then to an accusation of pornography. Finally, as set forth above, to be actionable, any such imputation would still have to be based on undisclosed facts. But here, if plaintiff's argument is that the photo suggests pornography, that photo is disclosed. Well, all right, yeah, who put that photo up there? If if the plaintiff's argument is that the photo suggests pornography, that photo is disclosed. So who put that photo up there? If you have a photo and you got a risque outfit, or you're not wearing any clothes, and you put the shit out there on Facebook or on whatever other social media site, um it's the photo has been disclosed, right? It was disclosed by you, correct? And I mean, I get it. Like, people, you do whatever the hell you want to on your social media, if that's her, because she's not suggesting who it is. Let's keep that in mind. She never said it was this girl. But if the photo is out there, and you got a little skimpy whatever on, I'm just saying, like, who put that out there? The photo is disclosed. Crazy, right? But hey, whatever. What do I know? I'm not an attorney. I'm just a little rabbit. Okay. Okay. The alleged statements concerning a criminal conspiracy are not defamatory and have already been dismissed. You said if the shoe fits. Stop it. Finally, plaintiffs tried to relitigate Corville's alleged statements concerning a purported criminal conspiracy. Even though these alleged statements were already dismissed by this court on the grounds that they constitute mere opinion and because actual malice allegations were lacking. Plaintiff's oppositions relies on the same allegations from their original complaint. The argument has therefore been before this court and decided, and any attempt to re-argument is barred. All right. Plaintiff's opposition fails to salvage their non-defamation claims. Joromovich false light claims must be dismissed. Joromovich seemingly concedes that the false light claims are subject to the same considerations as defamation claims, including the requirement to plead actual malice. Okay, the claim must be dismissed for the same reason plaintiff's defamation claims fail. Joromovich intrusion upon seclusion claim must be dismissed. Joromovich concedes that in pleading intrusion upon seclusion, she must plead the wrongful disclosure of private information. Yet much of the allegations concern the alleged disclosure of publicly available information, such as Jeromovich's home address, the name, and the address of the church Jeromovich attends, and Jeromovich phone number. Okay, these are matter of public record and makes clear, and as plaintiff cites, provenly. Okay. Regardless, even if Jeromovich's home address was private, the TAC only details one specific instance where this information was allegedly disclosed, and that disclosure was by some unidentified third party, a pleading deficiency with plaintiffs have entirely failed to address. Otherwise, Jeromovich only alleged the disclosure of such information without any details as to where or when the information was disclosed or by which defendant. Jeromovich also fails to address her lack of understanding to bring a claim for intrusion upon seclusion for private information of other people. To the extent Jeromovich points to to the introduction to the TAC rather than the allegations therein. That is inappropriate. This introduction does not constitute the pleading itself under Rule 10b. Okay, let me stop right there. This thing is driving me a little bit crazy because I'm thinking, right? So Lima took the role that she did with Amanda Rapp. And let me be very clear so y'all don't construed my words, all right? Because I know y'all like to do all that shit and then whatever. But let me just say this, okay? If you are a professional working in the field, okay, you would not be going on a no jumper podcast, a soft white underbelly, any other podcast and talk about your client's stuff. Just like you wouldn't disclose it about your sister or your sisters, you wouldn't disclose it about your clients. You wouldn't even be up there discussing the autopsy report or any of that matter or any of those. You just wouldn't, you would not. Okay. It's one thing to say, to have, at the time that Amanda Rabb was alive, it's one thing for her to have gone to Soft White Underbelly and given her story and shared it and asking the public to help for her treatment that was being funded. That's one thing. But it's completely different when you have the actual professional that is asking for funding and telling people what this treatment is. You don't do that as any type of mental health professional. You don't. How come nobody tapped her and said, "Listen, what are you doing? You don't do that." She does it for investors, potentially. That could very well be the case. But when Amanda Rabb was alive, that's what Amanda Rabb could have done that. It wasn't for Lima Jevremovic to do it. She shouldn't have done that. That's frowned upon. You don't do that. That's like me if I go up here and I'm asking for say somebody needs treatment, okay, in my chat. And I'm their, I know their whole treatment file, right? Let's just put it that way. I know their file, I know what they're going through. And I decide to go on a platform and talk about so and so Pika's treatment. Pika, I'm picking on you. Pika's treatment. I'm gonna go on Soft White Underbelly and talk about, this great treatment, and I'm gonna use you can't do that. Don't do that. Don't disclose that shit. You just don't. I don't think you're right, Kim. Not only does she not, but she doesn't understand. And there's a lot of shift blaming for sure. Like, you didn't have to go on any public forum to talk about it. Matter of fact, in the future, don't do that. Don't, like, if you're working with somebody, don't do that. That's right. Can I just take a moment and say the fluff is the shit? But you don't. Hey, infamous. Hey, everybody. Welcome, welcome for those that are coming in. Look, test me if you want to. All right. But it's the truth. You just don't do that. So, I mean, I don't know if she's going to learn from this. But that's what she needs to understand. You just don't. And that's the $1 million question. Ask her. Anybody should be able, any treatment facility, should be able to tell you that. Right. She's not trying. She's not trying to understand, Chico. You are so right about that. You're so right about that. Okay. Okay. Let's get it together and let's keep going. So I read that part. So moreover, Jevremovic fails to address another pleading a deficiency defendants note in their opening statement. The claim requires the information to be wrongfully obtained. That is not pled in the TAC or defendant in the opposition. Mm-mm. You have so much work. You want it? I know I gotta buy. I'm still like I bought something and it hasn't gotten here yet. So and I'm wanting to buy a lot of things, but I might go broke if I buy everything. So yeah, and I know that there's gonna be some sales coming up pretty soon. So keep that in mind. Matter of fact, I think there's like free shipping that's gonna be happening. I think it's the 17th. So just wait on it. Don't order right away. Okay, and I'll make sure I announce it on the community wall. All right, so Jevremovic harassment claims must be dismissed. Let me see, where am I at? Okay, we're almost done. Jevremovic pled in her TAC that defendants are liable for harassment under the New Jersey SA, and then there's the code there. Jevremovic fails to address the clear case law that there is no private right of action under this criminal statute. Jevremovic then somehow argues that she has pled a claim against Corville under the Domestic Violence Act, but ignores that only a victim of domestic violence can file a claim under the statute, defined as a spouse, former spouse, or any other person who is a present household member or was at the time a household member, or with whom they have a child in common, or had a dating relationship, which I'm pretty sure none of those are BJ. Additionally, to take advantage of the DVA, domestic violence victims must file the complaint in the family part of the Superior Court, in addition to other procedural requirements with which Jevremovic failed to comply. Jevremovic emotional distress claims must be dismissed. Jevremovic emotional distress claims must dis- distress claims require her to plead that Corville caused her some severe, disabling emotional or mental condition or resultant serious psychological or physical illness. Ooh, okay. Um, Jevremovic, without explanation or citation, says this requirement of serious psychological or physical illness is not controlling law, yet it is consistently borne out of the case in defendant's opening brief, none of which have been overturned. Hmm. To meet this burden, Jevremovic cites a series of conclusionary conclusions. I can't even reach conclusion allegations in the TAC that she suffered devastation and emotional distress. Allegations defendant pointed out in their opening brief and noted are precisely the kind of boilerplate allegations New Jersey court have found to be insufficient. Otherwise, Jevremovic only cites to a study by the Pew Research Group and a 2015 paper about cyber harassment describing generally the types of harms that can be generally caused by cyberbullying. But these allegations say nothing about the specific psychological or physical illnesses actually suffered by Jeromovich herself. Well, yeah, like who did you go see for all of this physical ailments? These general sites are not a stand-in for a plausible allegation of facts setting forth Jeromovich's physical or psychological harm alleged to have been caused by defendants, an element of both intentional and negligent infliction of emotional stress. The claims are also false because Yoromovich herself concedes she must plead actual malice. The failure of actual malice are set forth in details herein alone defeats Yoromovich emotional distress claims. Let me drink some water. Yeah. Did she see a doctor? Did she see something? I'm wondering. Hold up, let me see. Well, I mean, she said that, it was a lot of emotional distress. I don't know. Right, Cheeks. Let me hand you we got to get a drink on this one. It's water though. Yeah. I don't know. It's weird, but I thought I'd put this out there. Okay? Plaintiff's unfair competition claims must be dismissed. Unfair competition claims can only be brought by a business against another business for the misappropriation of the business property. The misappropriation of a business property is one of the few fundamental and definite elements of unfair competition claims. Accordingly, such claims are barred outside of the intellectual property context. Plaintiffs failed to address any of this case law. Well, damn, like BJ's attorneys, what else have they not addressed? They've been like failing to address, failing to address, failing to address. Okay. Instead, they boldly argue. He said did he mean to say boldly or baldly? Oh my God. He said, but look at, I'm not making, did they boldly argue that Jeromovich and Corvio are somehow themselves a business, while at the same time ignoring that a separate business entity allegedly associated associate with each is party to this case. That's what they said. I'm just saying. I don't know. I don't know, but somebody must. Girl, get your money back. Girl, get your monies back. Like, ask them for a refund. I mean, is it too late for a refund, y'all? Because that'd have been like, refund, please, por favor. I'm just saying. I'm just saying. I don't know. Okay, let's keep reading. So, here we go. Here we go. Here we go. All right. So, moreover, the plaintiff suggests that defendants have allegedly frozen investments in ARA. Ooh, I didn't know BJ could freeze investments. This argument ignores that the wrongful conduct they allege that led to this harm was defamatory statements. And as defendants made clear in her opening brief, and plaintiffs do not refute, defamation cannot sustain an unfair competition claim. Plaintiff tried to make the desperate argument that defendant misleadingly used competitors' information to manipulate search engine results. What? But that is not what they pled in their TAC. In their pleading, they allege only that the top search engine results for Jeromovich and Ara are now almost all defendants' faults and or intimidating social media content. This was not an allegation underlying the unfair competition claim. In any event, it's it falls far short of a plausibly alleging the defendant misleading use plaintiff's information to manipulate search engine results, particularly as a defamatory statements are not alleged to be a misleading use of plaintiff's information. Hmm. Interesting. Interesting. Oh my gosh, y'all are so funny in the chat. Hold up, let me read. She said, "You know they put a warning label on you, something like may trigger tears in overly sensitive rabbits because you make those fragile stickers look tough." I know she says frozen investment. Go BJ, go please. Oh, sorry, no, no. I don't know how you would freeze. How do you how does a person have the power to freeze somebody's investment? Like, did the person say I'm freezing the money that I'm going to give to you? Maybe people are doing research and they're like, this shit's not working. Like this is not what this was. It can't be. Okay. Here we go. And this is, hold up. Let me see. 13 and we are almost, yeah, we're almost done. Okay. Let's go. Let's go. Let's go. The opposition fails to salvage the claims against Benny Paul and the LLC. In support of their alleged 9 out of 10, they bold 9 out of 10 of their claims against additional defendants, Benny Paul and the LLC, plaintiffs argue only that Benny Paul produced Corville statements and the LLC broadcast them. Wow. So they're even they've mentioned Prem, we know that. But what plaintiffs actually allege in their TAC is different. They allege that Benny Paul was a de facto producer for Corville's social media channels with the phrase de facto producer, undefined and unclear, and that the LLC was formed to carry out defendants' activities, not to broadcast them. These scant allegations do not plausibly demonstrate Benny Paul or the LLC participation in the action set forth in the plaintiff's claim. Even if someone even if somehow an allegation of being a de facto producer is meaningful, this is not nearly enough to survive a motion to dismiss. Plaintiffs have cited no case law supporting their blanket statement that the mere suggestion that someone produced defamatory content is enough on its own to make them liable for all that defamatory content. Indeed, New Jersey court requires to show the defendants adopted the statement as their own. Okay. In fact, plaintiff's case law highlights the factual void with respects to the allegations of Betty Paul's and the LLC participation in the alleged defamatory content. In the case they cite, okay, they cite that case. The court declined to dismiss the defamation claim against certain defendants because the complaint alleged meaningful participation by each defendant, that the defendants ran the day to day operations of the company, direct, draft, distributed, and prepared for publication, the defamatory publication, and communication with press to spread the statements. Those allegations are a far cry from the bare bones, ooh, he said bare bones allegations plaintiffs pled as to the role of the Benny Paul and the LLC in of the any of the alleged defamatory conduct. Indeed, accepting plaintiff's allegations as sufficient would implicate anyone affiliated with Corville as liable for her alleged statements. Yeah. So that's it. That yes, yes. Thank you for saying this, sir. And they cite the case. Without a more specific allegation, the court cannot simply infer that they were involved in the creation of publication of the statement at issue. If that were the case, all officers, employees, and authorized agents of the defendant would be vulnerable to defamation charges. I mean, all of us. Y'all, it's like what they're trying to do with the what the house. They're trying to hold everybody accountable for shit that it's like, what? Shout out to this attorney. I mean, my goodness. My goodness. Nor does the opposition salvage the statute of limitations bar as to the only statement many Paul is alleged to have made. As made clear in the defendant's opening brief, the relation back doctrine can only save the expired claims against Benny Paul and the LLC. If the original complaint put them on notice that they would have been sued but for a mistake to as to their identity, but the complaint failed to mention anyone but Corville and failed to mention Benny Paul's sole alleged acts of defamation at all. Thus, as made clear by the New Jersey courts, relation back cannot save plaintiff's untimely claim. Nothing in the opposition refutes the clear message that plaintiffs did not misidentify a party, simply failed to include one. Okay. Plaintiffs fail to engage with any of this case law or relation back doctrine requirements. Instead, they cite to case law applying the relation back doctrine in other contexts, not in cases where the relation back doctrine would allow otherwise time barred claims against new parties. Then there's a citation for a case. Plaintiffs should not be allowed to file a fourth amended complaint. No, they shouldn't. They need to make a decision on this ish. It really is absurd. It's absurd. All of this. All of this. So this reply is basically saying we're going to drag our feet so we don't have to pay up. This document is legally for we're dragging our feet so we don't have to settle. Truly. Truly. I mean, seriously, right? I cannot. I cannot. All right. So you said Elizabeth. Yeah, yeah. You know the Theranos lady who was in trouble? Uh-huh, uh-huh, uh-huh. Okay. Let's keep reading because we're almost done. Plaintiffs should not be allowed to file a fourth amended complaint. Plaintiff's case law confirms that the opportunity to amend should be denied where there has been repeated failure to cure deficiencies by amended previously allowed. Okay, here not only have the defects remained uncured with amendments, but the deficiencies were laid out in several pre-motion exchanges. Plaintiffs should not be permitted to continue forcing defendants to incur legal fees in defending against non-viable claims. That is bing, 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 bing. Stop trying to fuck people over on this legal system and then try to rack up these fees. That's what this was. Yes. Yes, ma'am. Uh-huh. Yes. Right, Terry. You are so right. Ah, yeah, 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 yeah. You think rabbits are all sweet and carrots? Think again. Rabbit got the instinct of a wild hare. Truth bombs. People underestimate the. They do. Infamous. Thank you. Shout out to you guys. Y'all are the flufful. People underestimate the power of the rabbit. Yes, they do. Yes, they do. Shout out to you guys. Okay. Conclusion. For the reasons set forth herein in the defendant's opening brief, defendants respectfully request that the court dismiss the third amended complaint with prejudice. And then it's signed. It's signed and signed and signed. That was a read, y'all. That was a read. Let me Holy Spirit activate this because that was a read. And it's been a minute. Shout out to Sean Davy Way. You guys know. Shout out to Sean Davy Way. That's my boo. Love you, love you. This is for him.
You cannot. Hold on. Okay.
Holy Spirit,
activate. You better do it, Lord.
Holy Spirit, activate.
You better get him, Lord.
Holy Spirit, activate.
Before I get him, Lord.
Activate.
Hey.
Activate. Let's go. Holy Spirit, activate.
Oh no.
Holy Spirit, activate.
Okay.
Holy Spirit, activate.
Okay.
Activate.
Hey, hey.
Let's go.
They say I ain't saved because I cuss a little bit. But you're the only judge that I need, and that's it. They always in my business because they say I backslid. They read the Holy Bible, but they ain't applying it. So Holy Spirit, activate. If you do it right now, that would be great. I ain't trying to smack this chick in the face. Don't you see me down here trying to change my way? So
Holy Spirit, activate.
You better do it, Lord.
Holy Spirit, activate.
You better get him, Lord.
Holy Spirit,
Before I get him, Lord.
activate.
Hey, hey, hey.
Oh my goodness. Yes, yes, yes. It's a Holy Spirit activate. You guys go check out my boo, Sean Davy Way. It's a Holy Spirit activate. I don't listen. It's got to be activated. Seriously. Shout out to everybody. Y'all are awesome. Thank you. Thank you. Shout out to BJ. I mean, you guys go support her legal fund. Did I put it in the I don't think I put her legal fund in the description box. Hold up, y'all. It's the GoFundMe. Well, let's see if I can pull it up. Legal fund. Make sure I drop it. I know somebody's got it. Here it is. Facts ain't defamation. Here it is. Here it is. Here it were. Here it is. Here it is. Here it is. Here it is. Hold up, y'all. Let me click it one more time because I lost the link. And then we can get out of here. Yes. What did she say? Love you, Kamina. Bye. That's right. That's that girl. There you go. Go support her, please, if you can. $5, $2, whatever you can do. You guys know, if you have it, you have it. If you don't, that's fine. The biggest thing that the best way to support BJ at this point would be just to share just to share the live. Just to share the live. Can you donate for each for such a cost outside of the US? I don't know. Holly, I don't know. You might have to look into that with GoFundMe because they have that, but she's also got like Cash App and all that other stuff. Whatever you guys can do. All right, y'all. I will let you guys go. Please note that we will be celebrating our 60K. We'll have like a little nightclub dance party, something, 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 something. Dropping the link. We'll do it. We got to do it big because this is 60, right? We got to do the 60 pretty big. Okay. I will see you guys on the next one. Y'all hit the like button. Rabbits out. Bye, guys.